In this installment of our discussion of school law and policy, we're going to talk about teacher freedoms, and public school teachers are afforded the same constitutional rights as other citizens. They don't relinquish their rights as a condition of employment, but teachers have constitutional rights. They also must be exercised prudently because of the role that they play in the lives of the children that they serve. So there's always this balance, a regard for the integrity of the teaching profession, the interest of the school district weighed against the personal interest of teachers in resolving conflicts involving their teachers. So the whole freedom of expression, just like citizen rights, they're derived from the First Amendment, the Bill of Rights of the Constitution. So a couple of cases here that we want to look at that really sort of clarify this issue in employment law in general is the Connick v. Myers case. This is a non-education case where the Supreme Court addressed First Amendment employment situations. This employee was an assistant district attorney, and at the time she performed responsibilities very effectively, but had an involuntary transfer over her objections. And she then developed and disseminated a questionnaire to elicit views of other staff regarding the organization, the transfer policy, morale, things like that, and looked at the overall confidence as to whether employees felt pressured to work in a political campaign environment, a whole bunch of stuff. And so she was terminated shortly after disseminating the questionnaire based on her refusal to accept the transfer and for insubordination in disseminating the questionnaire. She filed a civil rights suit claiming that she was wrongfully terminated, and the court held for the defendant on the basis that Myers did not speak as a private citizen on matters of public concern, but only as an employee on matters of personal concern. So the First Amendment cannot be used to offer protection in a situation where you're criticizing your employer for something that they did to you. And so you have to look at whether you have your employee hat on or your citizen hat on. And that is further clarified in the Pickering case. Marvin Pickering was a teacher dismissed for writing and sending a letter to the local newspaper. The letter was critical of the Board of Education spending on athletic facilities compared to academic facilities, and the board's way of not informing the public of the real reasons why taxes were needed for schools. Pickering was terminated by the board based on its view that his letter was detrimental to the efficient operation of schools in the district. Some of Pickering's statements in the letter were true, a couple were not. Pickering challenged the constitutionality of his dismissal, and the court held for Pickering based on the fact that his letter was, in fact, a matter of public concern and protected by the First Amendment. And so while even though some of his statements were untrue, that really, he still exercised his right as a citizen to First Amendment freedom, the right to expression, and it has to be balanced against the state interest of an efficient school, which the court said was not at play in this case. Retaliation speech in any form is illegal, and it is not supported by the courts when school officials take actions against teachers who lawfully exercise First Amendment rights. Retaliation most often occurs when teachers criticize administrative practices or decisions that have implications for the school community. And this sometimes is closely connected to the Connick case, like unjustifiable transfers, demotions, extra duty assignments, or thereabout. The court tends to scrutinize these issues around the First Amendment involving free speech pretty closely, because adverse action taken against school personnel who exercise their First Amendment right to free speech. So this Burgess versus Independent District in Oklahoma, this was a high school teacher who was told by a shipping company that pornographic materials found in a dumpster had been ordered by a principal. The information was reported to the superintendent by the teacher with the request that an investigation be conducted. So this is a whistleblower. The principal eventually came forward and admitted that he had ordered these materials. And Pickering was terminated by the board for making false statements, but then later reinstated in a less desirable position. And of course, Burgess, the art teacher, sued and wanted his original position back, and the court agreed that he did not deserve to have retaliation against him for being a whistleblower. Mount Healthy school case versus Doyle was a non-tenured teacher who had been involved in a lot of altercations with other teachers, employees, students, including an incident in which he made an obscene gesture to a female student. He called to a local radio station the contents of the principal's memorandum to faculty regarding dress codes for teachers. The station aired the contents of this memo, and shortly after, the school, on the recommendation of the superintendent, informed Doyle that he would not be rehired. The board cited a lack of tact in handling professional matters, obscene gestures, and the radio station incident. Doyle challenged the validity of his employment termination based on the grounds presented by the board. The court held for the school board based on the fact that Doyle was unable to demonstrate that his expression was protected and was a motivating factor in the board's adverse action. So if you compare Connick to Burgess to Mount Healthy, you can see the difference in the way these officials are acting as employees, but there's a differentiation in the Burgess case where that employee was also acting from the standpoint of doing the right thing as a whistleblower. Academic freedom is another issue. Public school teachers have a judicially recognized academic interest in their classrooms based on the teacher's right to teach and the student's right to learn. This is judicially recognized academic interest, and it's subject to limitations in public schools, unlike in universities, based on age, maturity of the students, the appropriateness of the materials, and the student's ability to handle the subject matter. This is a big issue today with many of the discussions about sexuality, race, and what have you. The point is illustrated in a lot of cases, but the Fowler case is a Kentucky case that is worth noting here. And this is a case that arose when a tenured teacher was discharged for insubordination and conduct unbecoming a teacher when she showed an R-rated movie to her class on the last day of school. She instructed a student who had seen the movie to edit out inappropriate parts. Even so, she left class several times during the viewing. There was nudity, violent conduct, and the student was not very successful as an editor, and the court ruled against the teacher and held for the district. And so the academic freedom is not an absolute First Amendment protection for teachers. Other free speech issues guaranteed by the First Amendment, the U.S. Constitution, can't be violated unless there is a legitimate and defensible reason to do so. And it's that standard we talked about with students also applies with teachers. Teachers may express their views on issues that are in the interest of the public. While teachers enjoy free speech rights, they're not without restrictions. They may not make damaging statements against their employers and make statements that violate confidentiality and loyalty that affect working relationships. They must be judicious. Teachers must be judicious in exercising free speech rights to ensure they receive First Amendment protection. And of course, this is very significant in the days of social media. Freedom of association is similar. It's also a First Amendment right. And of course, the 14th Amendment applies that right to the state level to public schools. So public schools are agents of the state, but they must respect the freedom of association with the rights of teachers within reasonable limits. So teachers have this right of the teacher balanced against the weight of the state's interests. Some of the cases, again, dealing with teachers who were involved with movements like the Communist Party even, are things that have to be weighed. And generally speaking, the right of the teacher to association and joining those kind of associations are normally granted. Social media world makes things a lot more complicated with many of these rights and freedoms and teachers' use of Facebook and other mechanisms. So social, it has to be looked at appropriately for effective educational purposes. Teachers need to exercise caution in their use of social media for personal reasons. They need to be extremely careful regarding the content of all these sites, Facebook, Twitter, Instagram, and many other accounts. Since teachers are viewed as role models by the courts, their actions may have a profound impact on impressionable students. And teachers have been terminated for posting inappropriate messages and images, as well as inappropriate relationships with students that are struck on social media. So teachers should not become Facebook friends with students. social relationships that might interfere with proper student-teacher relationships and create challenges for teachers regarding their ability to maintain effectiveness in the classroom. Several different court cases have borne this out to where posts on Facebook, especially where they share information about students. There's a New Jersey case where a teacher posted a picture of a student on the Facebook page with the comment of a warden for future criminals, and made allegations about what would happen with this student's future. In most of those cases, the students or the teachers have not fared well. And so there are numerous incidents, and I dealt with numerous incidents when I was a superintendent regarding this. We talked a little bit about their right of association, and that includes subversive organizations, but there's still controversy in this issue of membership in subversive organization and exactly what is a subversive organization. And so there are instances where employment was denied, where teachers were dismissed based on these memberships in such organizations. And in order to justify employment action against the teacher, there has to be evidence that the teacher actually participated in unlawful activities or intended to achieve unlawful objectives in their relationship to a subversive organization. So marching in Black Lives Matter rallies is not cause for not hiring someone or denying a teacher their rights. But if that person was actually looting and participating in behavior that rose to the level of being unlawful, then that is fair game as far as denying them employment rights or dismissing them or what else. The right to hold office is also something that does creep in as you see more and more teachers becoming politically active. State laws vary regarding the extent to which school personnel can legally hold public office. In case in Oregon, the district court held invalid a state statute prohibiting public employees from running for political office by declaring that the state had no authority to limit their First Amendment right. But a contrasting case in Kentucky, Allen County, Kentucky, nearby, the court held that a requirement calling for mandatory leave for all teachers who pursued part-time office violated the teacher's right to equal protection, since no such requirement applied to teachers engaged in other time-consuming activities. So the courts are still sort of inconsistent there, and that one may be one that rises to a higher court. As far as dress and grooming is concerned, there's little disagreement among courts regarding the school district's authority to regulate teacher appearance. That may disrupt in the educational process. What has not been settled is the degree to which constitutional protection of teachers are entitled to receive in disputes regarding dress and the type of evidence required to invalidate dress code restrictions for teachers. Dress and grooming issues peaked during the late 60s and early 70s, and we don't see as much of that anymore. The right to privacy is another one. Teachers enjoy a measure of privacy in their personal lives, which should be respected to the degree that they don't violate the integrity of the community or render the teacher ineffective in performing their professional duties. Teachers need to be reminded of the professional nature of their position and the impact their behavior has on children who view teachers as role models. The Erb case from Iowa is a leading case involving private adulterous activity. Erb is a native of Iowa and a high school arts teacher. He was married with 2 children, as was Margaret Johnson, a home ec teacher. Robert Johnson, the husband of Margaret, later caught Erb and Margaret in Margaret's car in a compromising position. Yada, yada, yada. And Johnson's goal was to have Erb removed from school based on this adulterous relationship with his wife, whom he later divorced. Erb and Margaret terminated their affair after which Erb offered his resignation. The school board voted unanimously not to accept the resignation. The board's president testified that Erb's teaching was highly rated by his principal and superintendent. He had been forgiven by his wife and the student body. He had maintained the respect of the community. Witnesses before the state board on Erb's behalf included Erb's principal, his minister, his parents, substitute teachers. The state board voted 5-4 to revoke Erb's certificate. The board's decision was challenged. The trial court held that Erb admitted adultery in a form of sufficient basis for revoking his certificate. He appealed the trial court's decision, and the Supreme Court held for Erb. So adultery by a teacher, even an adulterous relationship, even though you have to deal with the HR implications of that type of relationship in an employment setting, is not grounds for necessarily grounds for revoking their certificate. And so it is very dicey. But again, that standard of teacher behavior and their freedom in what they do outside of school is a significant element. And oftentimes, as an administrator, will creep into the work that you do on a daily basis.